I'm Vinnie Politan. Thanks for joining us tonight here on Closing Arguments. And I'm sitting here on a Monday night. 1 week from tonight, when I'm sitting here, the George Floyd murder trial will have begun. Think about that. We're just 7 days away from the start of this trial. And it seems like it was just a short while ago that this whole thing happened. Yes, this case is on a very rapid pace. As you know, sometimes it takes 2 years, 3 years, 4 years, 8 years to get to trial. But in this one, less than a year. It's been months. And as we sit here tonight, 1 week away from the start of this trial, the attorneys were in court arguing an issue that could severely impact this case. Believe it or not, they're in front of the appellate court as prosecutors are trying to get third-degree murder charges reinstated against the defendant, the lone defendant in the case, Derek Chauvin. As you know, the trial court judge threw it out and dismissed it. Prosecutors want it back in, so they went to the appellate division. Let's bring in Julia Janae, Court TV legal correspondent, who is on the ground in Minnesota, in Minneapolis tonight. Julia, great to see you tonight. 1 week away. This is unreal. But as we sit here tonight, 1 week away, they're arguing in front of an appellate court about this third-degree murder charge. Let's take a step back. What's the difference? I mean, he's already charged with second-degree murder. So what does third degree, is it different than second degree? How so?
It is different. The biggest thing it comes down to is intent. Now, the second-degree murder charge against Derek Chauvin is classified as unintentional second-degree murder, but there's a part of it that the prosecutors have to prove. They have to prove that there's an underlying felony, and that is an intentional assault. So they still do have to prove that Derek Chauvin was intentionally trying to cause serious bodily harm to George Floyd when he was pinning him to the ground. The caveat with third-degree murder is that they don't have to show that he was acting intentionally. There's a requirement that they show that he was acting recklessly, that he had a depraved mind, he didn't care about human life with his actions. A common scenario that you see with third-degree murder is someone who's driving drunk. It's not that they intend to hurt someone, but their actions are reckless, they're not caring about human life, and therefore they would be guilty of third-degree murder. So it is an easier charge, and as far as how difficult it is for them to convince a jury and what they have to prove to a jury in this case.
All right, and the difference in the sentencing?
25 years for the third-degree murder, up to 25 years, and 40 years is the max for second-degree unintentional murder. And keep in mind, the third-degree murder charge was the very first one that was charged against Derek Chauvin. That was the only one that he was charged with in the days right after George Floyd died. But then days later, when the Attorney General's office got involved with the prosecution, is when that second-degree murder was added to the charges. And then, of course, down the line, the third-degree murder charge was dropped.
Okay, now, the actual attorneys, two of them who will be making arguments and in the courtroom where you are in Hennepin County, we're arguing today in the appellate court. Let's take a listen.
Prior precedent, quote, remains good law until and unless it is overturned. Even though a prior case might not be final, we generally follow a rule of law until the Minnesota Supreme Court announces a different rule. And so, and there's many, many cases like this, Fischel's another one. And so, we think that this is actually a really settled question. And for the most important of reasons, Mr. Chauvin's argument would be a recipe for chaos.
If you look at the principle that Collins stands for, that is a principle that predates Collins, and Collins simply adopts it in the context of a criminal case. And then this court has repeatedly cited that principle in Collins as binding precedent. At page 15 of our brief in footnote 2, we cite several examples where the Court of Appeals has specifically found that a Court of Appeals opinion is not effective until the deadline for granting review has expired.
All right, so they're arguing virtually, obviously, because we're still in that world that we're in. But these are two of the attorneys who will be inside the courtroom arguing the case.
That's right. This is Eric Nelson. You heard there last. He's the attorney that's representing Derek Chauvin, the defense counsel, and Neil Kumar Katyal. He's a special attorney that was brought in by the prosecution. He's not licensed here in Minnesota, but he was brought on and approved by the court because of his credentials and his experience. He also has a lot of appellate experience, so he is the one who brought the oral arguments for the state today.
Okay, so breaking down what each side is saying here, and I'm trying to keep this simple because once we start getting into case law, I can hear some people reaching for their remotes, okay? So, but basically, the appellate court has ruled on this third degree in Minnesota, and prosecutors believe that the ruling by the appellate court that they're in front of now helps them, this new ruling. And the defense is saying that it's not a final ruling yet. Is that basically what each side is arguing?
It all comes down to timing. So the state says right when the Court of Appeals makes this decision saying that the third-degree murder charge applies in this other case, one we've talked about here on Court TV, the Mohammed Noor case, they say as soon as that decision happened that they are allowed to apply it in this case, the case against Derek Chauvin. But the defense says, no, it's not binding yet. It's not binding until the parties in that case are allowed to try to go to the Supreme Court. And breaking news from last week, the Mohammed Noor case has now been appealed to the Supreme Court. So we don't know how the Supreme Court is going to rule on it. The defense's position is until this case is completely done, as in they've exhausted all of their options, then you can't apply this case to the district court level. But the state today arguing that as soon as the appellate judges made that decision, they're allowed to apply it in this case.
Right, and you're basically, so the defense is in the position of arguing to the appellate court, listen, you guys got it wrong in that other case, so don't mess up this one. So I have a feeling, I don't know if you're with me on this, I have a feeling that the prosecution has a good chance of succeeding here.
I will say, if you were watching today, you got the sense that the appellate judges were giving the defense a harder time. They were asking a lot of questions. They were really grilling Eric Nelson because they didn't seem to find that his arguments were based in solid law. They said that the one case that he cited, that State versus Collins case, you heard him mention, that the discussion in that case about this particular issue wasn't even in the binding part of that case, that it was dicta, that it was offhand remarks by the court. So they really wanted to know why he felt that their decision is an awkward position he's in, because he's telling the appellate court that your decisions don't matter until a lot of time passes. But you could tell that they wanted to know, and they seem to believe that their decision should matter once they publish their opinion.
Yeah, it's always difficult when you go in front of a court and say, listen, you're wrong. You made a ruling, and you were wrong. And it's rare that you win that. Sometimes you can, I get it. But all right, we'll see. Now, Neil Katyal, again, presenting for the state, for the prosecution here, made some arguments today in how what's happening in this argument could impact the other three defendants who have their case scheduled for the summer. Let's take a listen.
Imagine the harm to the public, not just obviously in a case like this with the gravity it has, but in any case, to say prosecutors have to wait a year or more to bring homicide charges, that can't possibly be the law. And indeed, one reason why stare decisis binds trial courts is because of equality. That's something that I think all three of you were getting at in your questions to my friend. Like cases can't be treated unlike. But the district court's decision opens that door in every case. There are three other officers who will be charged much later, very possibly when Noor is over and left intact. That would mean third-degree murder charges could be brought against those three officers just because of timing.
Interesting argument. So basically saying if you don't bring this third degree now against Officer Chauvin, it could be brought against the other three just because their case is heard second.
Right, saying that it's not equal and that there has to be equal protection under the law, that the law has to apply equally to cases. So it's an argument that seemed to make sense. He's saying that this third-degree murder charge shouldn't be blocked from applying to Chauvin, and the Noor case, if it's decided in between now and when the other officers go to trial in August, they could end up standing trial for a charge that Chauvin doesn't have to face. But I think that it's a hard argument, because if Chauvin is convicted of the tougher charges, then it's not going to be much of a difference if these officers are also charged with third-degree murder, because they'll also be facing aiding and abetting the second-degree murder, which has a higher penalty. But that was an argument, and the judges, they seem receptive to that argument by the state.
Yeah, I'll tell you what, though, the bottom line is there's an upside and a downside to both sides in this whole thing. I mean, if third degree is put in here and he's found guilty of only third degree, and then the other third degree police death case goes to the Supreme Court of Minnesota and they overturn it, then they could overturn Chauvin, and then there's no conviction at all. I mean, it can go either way. So I think both sides are kind of tiptoeing around this. But you mentioned before, Julia, getting sort of a feeling for what was going on today in terms of the way the questioning was going. Let's listen to two of the judges questioning the defense attorney for Chauvin.
If the Court of Appeals precedential decisions are not binding on a district court when issued, and instead they're not binding until some later time, which you argue is, as I understand it, not until the period for a petition for review has expired and no petition has been filed, or the Supreme Court has denied a petition for review. Is that your position, basically?
Because I think where stare decisis is satisfied by the rules and by these timeframes is because the time is limited. It is a limited amount of time. It's not years and years and years. It's no more than 90 days and often less than 30.
Right, but counsel, you're only looking at the front end. I think we all know as practitioners that if the Supreme Court does accept review in a criminal case, it's often a year or more before we get a decision. So although the rules limit the time in which the parties can seek review by the Supreme Court, if your position is the decision of this court is not final until an appellate judgment is issued and the Supreme Court does take review, I mean, that means people could be waiting, 12 plus months.
I think that's the rarity that's the exception to the rule rather than the general rule.
So what you would envision then is a situation where, well, if the law is not crystal clear on this issue of third degree murder, if there is a case of a homicide and it may or may not constitute third degree murder, depending on which opinion from Noor you accept, the state should simply not charge that case until the issue is resolved.
I think that would
instead
be
of following the majority opinion from the intermediate appellate court.
I do think that would be an extremely rare hypothetical scenario, but would technically be possible.
Yeah, I get what you were saying there, Julia, about the way the questioning was, and I think so. When do we expect, and did they say when this decision will be made? Because we keep saying, we're 7 days away from the start of this trial.
They did, and these judges appreciate that. The presiding judge said that they are going to put out an expedited answer. So they didn't rule from the bench today, but they will be getting an expedited decision out, and they said that they appreciate the fact that they only have 7 days before jury selection in the murder trial. So we can expect that we're likely going to get an opinion from the appellate court before Friday.
Okay, and if the third degree is reinstated, will then prosecutors say, well, now we got to delay the trial?
The prosecution will not, only because of what they have put in prior filings. They've said that they don't need more time if the third-degree murder charge is added back, but they will not object if the defense wants more time. So it will then rest on Eric Nelson on whether or not he wants to go forward with third-degree murder back on the table for his client, or if he decides to ask for continuance, then it will be up to Judge Peter Cahill, who has denied all continuances up until this point.
Okay. Great job. It all made sense to me. I think it made sense to the folks at home as well. It's very complicated and convoluted, but Julie Janae breaking it down. Julie Janae is going to be back at the top of the next hour. We're going to talk about who's going to be allowed inside the courtroom during the trial. We've got some pictures to show you and let you know all that. Thanks so much, Julia.
Thanks, Vinnie.